We've got quorum. Alors?
Order, please. This is the Subcommittee on International Human Rights of the Standing Committee on Foreign Affairs and International Development. This is the 26th meeting.
Looking at a study, we're starting a study of human rights commissions. And we have two sets of witnesses before us today. First, David Langtry, Deputy Chief Commissioner of the Canadian Human Rights Commission. He is accompanied by Sébastien Seguin, who is the Director of the Policy and International Relations Division, and Monette Maillet, who is Director and Senior Counsel of the Legal Advisory Services at the Human Rights Commission. They will be followed by Alain Borovoy from the Canadian Civil Liberties Association. And I just want to alert members from all parties to the obvious time constraints that puts on us within a 1.5-hour window. I'm going to have to be pretty ruthless in maintaining, keeping our questions and the responses to them short in order to allow both sets of witnesses to be heard from fully. What I propose is that we have a single round of questions after, rather than the normal 2 rounds, after each set of witnesses. Even so, it's going to be tight. And I ask for everybody's cooperation. That being said, I do welcome our witnesses, and I would ask Mr. Langtry that you please feel free to start. Thank you.
Thank you, Mr. Chairman. Good afternoon. I thank the subcommittee for inviting the Canadian Human Rights Commission to participate in your discussion of policies and practices of human rights commissions internationally and in Canada. Je m'appelle David Langtry.
I am David Langtry, Deputy Chief Commissioner of the Canadian Human Rights Commission, or CHRC. With me today are Monette Maillet, Senior Counsel and Director of Legal Advisory Services, and Sébastien Seguin, Director of Policy and International Relations. We welcome this opportunity to provide you with an overview of the role and mandate of the Commission and to describe our practices and work both domestically and internationally.
The role and mandate of the Commission is to read an excerpt from Section 2 of the Canadian Human Rights Act. The purpose of this Act is to extend the laws in Canada to give effect to the principle that all individuals should have an opportunity, equal with other individuals, to make for themselves the lives that they are able and wish to have without discrimination. This sets out the mandate that our Commission pursues in all our work, helping to create a Canada with dignity, respect, and equality for all. The Commission itself consists of 2 full-time members, myself and Chief Commissioner Jennifer Lynch QC, and 4 part-time members, together with 190 staff. An important aspect of our work is dealing with complaints of discrimination. Most are in the employment context, and about 1/3 are about discrimination based on disability. Experience has shown that often the best way to resolve human rights disputes, most of which occur at the local level, on the shop floor, or in an office, is to bring the parties together to work out their differences. That is why the CHRC provides a robust system of alternative dispute resolution. ADR is offered at every stage of the process and is often successful. Of course, not all complaints can be resolved in this way. The remaining cases go through the statutory process of investigation and a decision by the Commission. About 86% of the time, complaints are resolved or closed at the Commission. The balance are referred to the Canadian Human Rights Tribunal, which is a completely independent hearing body apart from us. While perhaps best known as a complaint screening body, the Commission fulfills another extremely important function, that is serving as a catalyst for advances in human rights. We perform an education and outreach function. We work with employers to help them integrate human rights into daily practice and prevent discrimination before it happens. We develop research, policies, and tools, and give advice to Parliament. In the 30-plus years since its creation, the Commission has contributed to making positive changes in Canadian society. Many of you will know of some of the precedent-setting cases that have made a huge difference for communities seeking equality. Via Rail, which provided accessibility for persons with disabilities who travel on trains. Sangha, which confirmed that discrimination on the basis of overqualification can be discrimination on the basis of race. VADE, which confirmed that human rights law applies to the House of Commons. And Multani, which clarified the interplay between human rights and security. As society and the law evolve, new human rights issues constantly arise, and the CHRC contributes to resolving them. À plusieurs reprises, des modifications ont été apportées.
Our Act has been amended on several occasions to meet the changing needs of society, such as including sexual orientation as a ground of discrimination, and establishing the responsibility of employers to accommodate, to the point of undue hardship, the special needs of employees resulting from, for example, their religious requirements or disability.
Of Section 67 of the Act, the section which excluded matters falling under the Indian Act. The passage of Bill C-21 was a milestone in the development of human rights law in Canada, and the Commission applauds the cooperation shown by parliamentarians in working to reach a consensus on the legislation, which finally gives First Nations peoples access to the same level of fundamental human rights protection that most Canadians take for granted. Repeal of this section was just a first step. The Commission is now working in close collaboration with First Nations organizations to build a human rights system that reflects and respects Aboriginal peoples' cultures and traditional laws. An issue of particular recent controversy regards Section 13 of the Act, which deals with hate messages. In response to concerns about Section 13, the Commission undertook a comprehensive policy review. The results of the review are detailed in the special report to Parliament that was tabled in both houses last Thursday. As you know, your colleagues on the Standing Committee on Justice and Human Rights have agreed to conduct a study on Section 13. We welcome and look forward to having that informed debate. I would now like to tell you about the international aspect of our work and some recent developments on that front. In the early 1990s, the CHRC chaired an international initiative that led to the adoption in 1993 by the United Nations General Assembly of a set of standards for national human rights institutions that came to be known as the Paris Principles. The Paris Principles serve as the internationally recognized benchmarks to assess the composition, mandate, and performance of a national human rights institution. Since their adoption, the Paris Principles have provided guidance to governments from around the world in establishing national human rights institutions that are independent and pluralistic. An independent, rigorous, and transparent accreditation process gives substance and credibility to human rights institutions. 88 national human rights institutions worldwide are now accredited in accordance with the Paris Principles, 65 of these with the highest A status, including the Canadian Human Rights Commission. All of these institutions are members of the International Coordinating Committee of National Institutions for the Promotion and Protection of Human Rights, or the ICC. The CHRC was elected as chair of the ICC in 2007 for a 3-year term. Under our leadership, the ICC has matured significantly as an organization. The ICC is working to provide a role for national institutions in corporate responsibility and has been very effective in promoting the role of national human rights institutions at the United Nations. At the regional level, the CHRC has played a leading role in the development of the network of national human rights institutions of the Americas. This network has provided its members with a wide range of capacity building and information sharing services, ranging from the role of NHRIs in promoting and protecting the rights of Indigenous peoples or the rights of persons with disabilities to human rights and security measures, right to education, and prevention of torture. And more recently, the CHRC has effectively promoted at the Organization of American States a role for NHRIs similar to the one they have at the UN. A reflection of the Commission's international work at home has been its participation in the Universal Periodic Review of Canada. It made a submission to the United Nations Human Rights Council to contribute to the first part of the review, which took place in February 2009, and intervened before the Council at the conclusion of the review in June. With this, I conclude my remarks. We welcome the opportunity to answer your questions.
Thank you very much. We'll start then with questions from the Liberal Party, and I believe that Mr. Silva will go first.
Thank you. We were just trying to figure out who the chair was. I guess Jennifer Lynch couldn't make it today to the meeting, and which is unfortunate. First of all, congratulations on your chairmanship. I think it's great. It's good for Canada as well. And I want to ask two questions in relation to international scene. One is that we just had the review, the periodic review for Canada. I want to know whether A, you can comment on that, and B, if there's a role as well for the Commission to play in some of the possible implementations of the periodic review recommendations that came forward. And number two is the fact that you also mentioned the Organization of American States. Now, the Inter-American Commission on Human Rights is very well known, and very prominent individuals have raised some serious issues of human rights, and but they also do a credible amount of good work on reports. I think of the report on forced disappearance, for example. I'm wondering whether the Commission as well does similar work to the Organization of American States human rights reports that they do, and whether that is sort of distributed, like their reports are very well distributed, and it's very well respected as well internationally. So if you can comment on those two issues.
Yes, thank you. I'll deal firstly with the UPR, and then I would ask Mr. Seguin to answer in terms of the Organization of American States, since he is the one who has been doing most of the work with the OAS. Regarding the UPR process, indeed, we, the Canadian Human Rights Commission, welcome that process, and as chairs of the ICC, we did conduct workshops, regional workshops internationally to assist national human rights institutions to participate in that process. We welcome the opportunity in the fact that all states, all member states would be under the review, and as you know, Canada certainly had supported that process. We did provide a submission in February, as I had mentioned, the 5-page submission, and this was not solely by the Canadian Human Rights Commission, but we as well consulted with all of the provinces through the Canadian Association of Statutory Human Rights Agencies, so all 10 provinces and 13 territories we engaged with, as well as with 60 NGOs. In developing our submission, and we did that through Rights and Democracy. So we made the submission, and as I mentioned, of course, we attended and intervened last week. We think it is a good process, and certainly I believe that our experience is that it opened the door to greater dialogue and engagement with civil society and the government. As far as our role in terms of any follow-up work, yes, we certainly have offered to be part and parcel, should we be given the mandate by Parliament to do any kind of follow-up or reporting work that may be in terms of any of Canada's obligations and response to recommendations on the OAS. If I could ask Sébastien.
Thank you very much, Mr. Silva, for your question. With regard to the Inter-American Commission, you are correct that it's an institution with lots of credibility. And in fact, we are hosting next week a delegation of 2 senior officials from the Inter-American Commission who are coming to the Canadian Commission for 3 days to learn of our own experience in complaints process, learn from our expertise. And this is part of a project funded by CEDA. As you know, strengthening the inter-American human rights system is a priority for the Government of Canada. And as part of that process, it was felt that the Canadian Commission could contribute to this process, to the inter-American system, by sharing its expertise with the Inter-American Commission. We are, of course, a different kind of entity as the Inter-American Commission, but we do provide reports on the human rights situation in Canada. And Mr. Langtree mentioned the UPR, the Universal Periodic Review. We also provide independent report through what is called at the UN the treaty reporting process, which is Canada is, as a member of this or that treaty, human rights treaty, has to provide periodic reports. And as part of that process, we also provide reports to the UN on the specific issue, whether it's discrimination against women or any racial discrimination or any other human rights issue that Canada has adhered to through a treaty.
Thank you. I'm not sure if I have any more time.
You have 1 minute and 45 seconds. I should have mentioned that everybody has 7 minutes.
Okay, just on the mechanical also of the operations, is it between the Commission and the Tribunal? Is it the Tribunal that handles most of the difficult cases and the Commission less so? I mean, if you make a petition, you have to make it first to the Commission and then go to the Tribunal. You can't make it directly to the Tribunal, I believe.
That's correct. The Tribunal hears any cases that are referred to it by the Canadian Human Rights Commission. We do not make a decision on the merits of a case. We are a screening body, so when we receive complaints, we consider them, and we may either decide that we will not deal with the case because it may be beyond our jurisdiction, it may be out of time, or there may be alternate proceedings that are available. If we decide to deal with it, then we make a decision to either dismiss it or to refer it to tribunal for a hearing. We do not make a finding that discrimination occurred. That is done in the open hearing at the Canadian Human Rights Tribunal, which is separate and apart from us.
Thank you.
All right. Thank you. I should have made it clear. There's 7-minute question and answer rounds in order to allow us to finish by 1:15. Monsieur Dorian, s'il vous plaît.
Oui. Monsieur Langtree.
Thank you. Mr. Langtree, thank you for your presentation. It was interesting. You mentioned the fact that your commission was accredited, was given an A rating based on the Paris Principle. Are there B-level accreditations, and what would be the criteria? How would you judge upon the performance of the various commissions?
Yes, thank you for that question. The A status is, as I mentioned, the highest status. There are 88. We also have at the ICC B status, which are near to being Paris Principle compliant, but don't meet all of the, don't fully meet each of the requirements of the Paris Principles. So they're accorded a B status. A B status means that they do not have standing at the Human Rights Council. All A status national human rights institutions have full status to appear and speak to every agenda item at the Human Rights Council. We also have some C status, which are basically not Paris Principle compliant at all. So an application for accreditation is made by a national institution. It is then referred to the Subcommittee on Accreditation, which is a subcommittee of the ICC, and it considers the application. It is reviewed by the national Institutions Unit of the Office of the High Commissioner of Human Rights in Geneva, and an analysis is done as to, and each applicant has to provide material to substantiate its annual reports, its budget, description of its activities. Field officers as well of the UN will provide information and input, and then the Subcommittee on Accreditation meets twice a year to consider the applications and reaches a decision, a recommendation that is given to the ICC to either accept or reject the recommendations. The subcommittee itself, it consists of one representative of each of the 4 regions that the ICC is broken down into, which is the Americas, Asia Pacific, Africa, and Europe. And Canada is one of the 4 members of the Subcommittee on Accreditation.
Thank you. Could you give us some concrete examples of the type of criteria that would be used to judge a commission?
Sure, and basically what all of the Paris principles that we can certainly provide to you, it's a set of standards to make sure that a commission is, for example, independent of government, so it's not an arm of government and can act independently. It has to be national in scope, so the provincial and territorial commissions would not be eligible for accreditation, only the Canadian as a national organization. It must have a broad mandate, so rather than a narrow specific interest, must be autonomous in terms of its budget and have adequate funding in order to resource it. The appointment process is to be pluralistic, open and transparent, and again, also without undue interference, and a number of rules like that to ensure that they have a broad enough mandate. And a fundamental requirement is that the Commission itself has to be founded in legislation or the Constitution. There has to be a sound legal framework, so it's not a committee that's simply established by motion. It has to have a legislative base.
Vous avez encore 3 minutes.
Oui. You still have 3 minutes, sir. Thank you. Briefly, because we don't have much time left, but there is a debate that's ongoing and seems to be for people that are interested in human rights. It seems to oppose social and economic rights with the other types of rights, such as individual freedoms, etc. Could you tell us a little bit about how you view things? What do you think of this issue?
Yes, and interestingly, as you may be aware, all provinces and territories have some degree of social condition, either expressly stated or an aspect of social condition. The Canadian Human Rights Act does not have a social condition provision in it. In our annual report in 2003, we had urged and recommended that social condition be added to our mandate, and of course the mandate decision is that of Parliament. And just recently, last year, we had conducted a fairly extensive study on social condition. Professor Wayne McKay had been engaged to conduct the research, and his recommendation, with a lengthy and well-reasoned report and comparing to various jurisdictions in Canada, does recommend that the mandate of the Commission be expanded to include social condition. That research is presently being considered by us. We have posted the research on our internet, and we've certainly invited submissions from the public on that, and we'll then be making a determination in terms of what, if any, recommendations we might be making to Parliament.
Merci beaucoup. Monsieur Dorion. Mr. Marsden, please.
Well, as is usual, by the time the first sets of questions are being asked, I've got about 9 more that are blossoming. I want to say congratulations, first of all, on the work that you do. It's important work. On the front of the UPR, when you read the UPR of Canada, there was a number of countries expressed concern for our reluctance to adopt OPCAT, and I wouldn't mind your comments on that. I would love to have a copy of your presentation on the UPR, I think is very important. So my first question is, of the UPR evaluation of Canada's human rights record, what were the most significant ones in your opinion?
Well, that's an interesting question. I would have to say that certainly in our submission on the UPR, we had highlighted aspects of social equality and social condition, but we had also particularly focused, if I might say, on Aboriginal issues. We made specific reference, and by the way, we will be more than pleased to provide you with a copy of our submission. We had noted with regret that Canada had not concurred or signed on to the United Nations Declaration on the Rights of Indigenous Peoples, and we had as well noted our work in terms of the United Nations Convention on the Rights of Persons with Disabilities. So those would have been, and the Aboriginal one is of particular issue for us, and I can say that from the Canadian Human Rights Commission, that is the #1 priority stated within our commission, is our work on the implementation of the repeal of Section 67. We've established a National Aboriginal Office in Winnipeg, which is specifically geared towards the implementation of the repeal of 67. As you may, of course, be aware, the transition period for the full implementation of C-21, the Act to repeal Section 67, is a 3-year period. It was June of last year when it passed, so there are 2 more years before it has full application to Aboriginal authorities, but it does have immediate effect as against the Government of Canada. So we are receiving complaints, and obviously there may be a very significant volume of cases coming in the next 2 years, and that is why it has really been a focus of our activity.
Well, just a bit further on that point, none of us can avoid seeing in the media the last few days of Manitoba and the Aboriginal communities being hit hard by swine flu, and I suspect that that as they dig through the causes for that the overcrowding and some of the issues raised in the UPR will surface. I'm pleased to hear Mr. McKay's consideration of the fact that the Commission should be looking at the social conditions. Our belief, of course, is that part of a human right is not to live in poverty. And there's almost a predetermination of the poverty levels in Canada by the way our system functions, and that's going to take a much deeper look. But I have what's a potentially loaded question. I've talked to my staff today, and he's an American by birth, came to Canada, which shows an improvement of his judgment. But anyway, we talked about the absolute freedom of speech that's in the U.S. And of course, in Canada, the Commission and the Tribunal have had the issues of the McLean situation and other such things. And I'd like your comments on that balance that you try to strike between people's rights in regards to what they perceive as hate literature or hate media and the absolute right of freedom of speech.
Yes, thank you. And certainly it has been the position of the Commission. And again, as you know, we did table a special report to Parliament last Thursday, which we're pleased to provide to you as well, which really talked about the balancing and saying that in virtually all jurisdictions there is a balance that while there is the fundamental right of freedom of expression, that does not trump other fundamental rights. In other words, they are all put on an equal footing. The court has often talked, the courts in interpreting that have often talked about the need to balance, and when there are competing rights, to ensure that that is there. As you may be aware, we had engaged Professor Moon to do a study on Section 13 as well. And certainly in our special report to Parliament, we have commended that Professor Moon's report as well be given full consideration. On balance, after consideration of Professor Moon's recommendation and our consultations broadly with those who wanted to make submissions, and our own consideration of it, and having regard to the Supreme Court of Canada's decision in Taylor and Keegstra as an example in 1990, as well as Parliament's amendment of our Act in 2001 as part of the Anti-Terrorism Act to specifically include hate on the Internet as being part of our mandate, that our report for consideration by Parliament is that both regimes be maintained, with some modifications to clarify the definition of hate, because it has always been our Commission's view that it is only in the extreme cases that the matter should proceed further, and hence a decision in the McLean's case. As you know, our Commission dismissed that complaint, did not send it to tribunal, and in fact there have only been in our existence 17 cases that have been heard by the Canadian Human Rights Tribunal out of any of those that come before us. So what we're saying is that we have been adopting the Taylor test in our analysis at the Commission level and only sending on those more extreme cases, but we have also recommended that to clear any uncertainty, that Parliament amend our Act to make it very clear that it's only that very narrow, those narrow and most extreme cases that should be within our jurisdiction, and therefore we would also be able to more clearly dismiss those cases that come before us that don't meet that threshold under Section 41 of our Act, which allows us to fairly quickly make a decision that it's beyond the jurisdiction of the Commission rather than having to go through a full investigation.
Thank you very much, Mr. Marsden. Now turning now to Mr. Hebert.
Chair, Mr. Langtry, I appreciate you being here to give us your insights into the strengths and weaknesses of our Canadian Human Rights Commission system. Given the shortness of today's witness time, I would ask that you be willing to provide answers in writing to questions that we submit to you after this proceeding. Would you be okay with that? Great. And I also have more questions than I have time for, so I really urge you to keep your answers as brief as possible. Thank you. I note that in recent years, the Commission and the Tribunal have conducted secret hearings to withhold evidence from defendants, to conceal the names of accusers, and to even exclude a defendant from portions of his own hearing, among other things. I, too, am a lawyer, and as I'm sure you would probably know, such practices do not occur in regular courts. If they did, they would bring the administration of justice into disrepute. So my first question is, who approves these kinds of legal tactics? And the second question is, does either the Commission or the Tribunal have any sort of a manual of legal procedure that must be used during these hearings, or do they actually just make it up as they go along?
Thank you for the question. I appreciate the opportunity to, albeit briefly, as you suggest, to describe our processes. As you well know, of course, we are an administrative tribunal, and as such are subject to the rules of procedural fairness, and all of our decisions are subject to review on judicial review.
Document of legal procedure?
We have operating procedures that we follow, certainly, which is more in terms of the time periods within which complaints and responses must be followed and so on.
Anything like that would be appreciated.
Sure.
And my other question was, who approves the legal tactics that you use?
Well, there really are. The legal tactics, if you will, are conducted in the same way before the tribunal in virtually every case. When we would make any kind of special request, we have to establish before the tribunal. As you know, there's no hearings at the Commission.
At the Commission or at the Tribunal will make a decision as to whether or not to have, a so-called secret hearing on some of these issues. It's not directed by yourself or anybody in authority.
Well, if on one occasion when an application was made before the Canadian Human Rights Tribunal to permit one of the witnesses to give evidence, had to state the case. Our lawyer had to state the case as to why a great exception would be made to the usual, and the foundation of that was based on concerns of potential security or safety. But it's up to the tribunal then whether or not to accede to a request, and that was made in one instance that I'm aware of, and I'm only aware of one instance.
Okay. Moving on. It's not escaped the notice of parliamentarians that some commission investigators have broken the law. And here I'm referring to the posting of large amounts of hate speech material on the Internet by your investigators, the theft of Internet service during a recent investigation. I also note that the Commission has hired some questionable people. One was a former police officer who was kicked off the force because of corruption. An internal governance audit in 2003 gave the CHRC a failing grade for ethics, and it was found not to have had an ethics code or manual in 2003. Since that time, has the CHRC adopted an ethics code? And if so, would it apply to the screening of potential hires? Would it have prevented the hiring of a corrupt individual?
Just if I might be permitted to respond to the preamble before the question. The fact of the matter is that some of the information that has been in the media and some of the descriptions of what we have done, we feel are untrue. And as part of our special report, we have detailed what our process is. For example, the allegation of the theft of the Internet, that was untrue, and the RCMP investigation and the Privacy Commissioner investigation both came to the determination that there was either no evidence or insufficient evidence to proceed further. In terms of our code of conduct and ethics and the like, we are subject to, of course, all of the Government of Canada codes of ethics, codes of conduct, all of the legislation pertaining to all of our employees. We do not post hate messages, and I can tell you that the Commission would not condone any of our employees doing so.
Thank you. Now, your website tells us that just 2% of complaints, each year are Section 3 hate speech complaints. This indicates that so-called hate speech complaints are a relatively minor portion of what the Commission does. What's even more interesting is that it's the same individuals responsible for virtually every Section 13 complaint that has been sent forward to the tribunal in the last 8 years. I'm sure you know Richard Warman. Of the 14 complaints that have resulted in a decision from the tribunal since 2001, 12 out of 14 since 2001 have been brought by Richard Warman. So essentially, without Mr. Warman, it would appear that the law would not really be used that much at all. Is it true that Richard Warman has received over $50,000 in awards through the tribunal process over the years? And is it also true that the Commission has given him thousands of dollars more in expenses as a so-called witness to his own complaints?
I can honestly say I'm not aware of what awards Richard Warman, as you know, we're not the tribunal. I do not know. I do not have a number. We can certainly look into that. I certainly have no knowledge of any amounts that that the Commission has paid to Richard Warman. I'm not aware of that, and I certainly can seek that information and provide it to you.
Very much appreciate that. Thank you very much. It certainly would be suspicious to have an individual who was a former employee being paid to be a witness at his own complaints and then receiving such awards. In your recent memo to Parliament last week, you claimed, as you did earlier today, that there's no hierarchy of rights, only a matrix of rights in which all rights are equally important. But our Charter of Rights and our Bill of Rights both list freedom of expression as a fundamental right. one that takes precedence over other values in society. Why does the CHRC not believe that freedom of expression is a fundamental right? Follow-up question. In the report, you also indicate that freedom from hate is a priority that's given equality to freedom of speech. This concept of freedom of hate is in the title of the document. Could you tell me where in the Charter or where in legal context in Canadian law does this freedom from hate exist, or where was it first described or invented? Two questions.
I can't give you the origin of where that existed, but certainly, obviously, from our perspective, it came from Parliament in terms of our mandate to deal with hate on the Internet. Section 13 is a creature of statute, as you know, and came from the mandate of Parliament. In terms of the balancing and the limit, that was, as you know as well, considered head-on in light of the Charter by Taylor, by the Supreme Court of Canada in Taylor in 1990. And the decision at that time of the Supreme Court, they released both the Taylor and Keegstra decisions on the same day, and they upheld the constitutionality of both Section 13 of the Canadian Human Rights Act as well as Sections 318, 319 of the Criminal Code of Canada. So it is based on that, and then again, as I had referenced, the 2001 amendment to our Act, again by Parliament, that as part of the Anti-Terrorism Act, to expressly state that it did cover hate on the Internet, which the tribunal had already determined was the case. So we take the mandate from Parliament, and we take the balancing, if you will, and the restriction on freedom of expression from the court cases. These are not decisions that are taken by the Commission. We are subject to Parliament and the mandate that you as parliamentarians give to us or take away.
That completes the questions that members can ask. I don't normally do this, but I'm just going to ask one question very briefly. Just with regard, Mr. Sweet, yes.
Just want to say this is a very important issue, one we had a very spirited debate about. And I'm very glad that Mr. Langtree already responded to my colleague, Mr. Hebert, and said that he would submit written answers to questions. But we gavelled in the meeting late, so we've had 39 minutes in this meeting. And the parliamentary tradition is that everybody gets an opportunity to question. So I would just like to, and I'm not certain if Mr. Ray feels this way, but I know that that is the case. And when we met as chairs of all the committees earlier this year, and I would hope that in future when we schedule, that we schedule enough time so that, particularly when it's an important issue like this, that everybody gets an opportunity to question their concerns to the witnesses.
That's a good point. I was about to pose a question of my own, and perhaps what we can do is invite the witnesses back at a later date if they're willing to come back to ask further questions. I did have one follow-up I just wanted very briefly to put in here on my own, and it's this, Mr. Langtree. Did I just understand from your last comment that essentially the precedents you look at are only those that come from the courts as opposed to previous decisions of the tribunal? Do you distinguish that way?
Oh, certainly we're bound by the decisions of the tribunal, absolutely. So both the courts obviously inform us greatly, but the tribunal decisions are ones when we refer a case on. It might be on an issue of duty to accommodate, for example. The tribunal will make a decision, and that is then what we in our investigations and our consideration of the case do follow those of the tribunal and the Superior Court, the Federal Court and the Supreme Court of Canada. Not so much binding on us are provincial court decisions.
Right. Okay. Thank you very much. We have to suspend momentarily while we bring our next witness in. We do appreciate you coming here. Thank you. to return to their seats. We are about to gavel in our next witness. Order, we're back in session. Our next witness is Alan Borovoy, General Counsel for the Canadian Civil Liberties Association. Mr. Borovoy, we are very glad indeed to have you here as a witness. We apologize for the fact that we won't give people as much time to ask you questions as you deserve and they deserve, but at any rate, the floor is yours.
Thank you very much, Mr. Chairman. The problem is exacerbated in my case because I tend to speak slowly. I think that in view of the polemics that have preceded these hearings, it would be appropriate for me to begin by indicating areas of agreement that my organization has with the defenders of Section 13 of the Canadian Human Rights Act. And I can state these agreements in three ways. First, or rather 3 points. First, we agree that freedom of speech is not and cannot be absolute. Second, as far as a hierarchy of freedoms is concerned, there's no necessary priority that one freedom has over another in the abstract. The priorities are intelligently worked out in concrete situations, not as a matter of abstract principle. Third, we agree that the bulk of our human rights legislation ought to remain, and that the agencies created to enforce it should be encouraged to continue doing so, because most of it is very helpful and very important. Those are the areas of agreement. I turn now to the areas of disagreement. While freedom of speech may not be absolute, it is nevertheless the lifeblood of the democratic system. It's the vehicle that enables any of us to mobilize or attempt to mobilize public support for the redress of our various grievances. My favorite philosopher once described it as a strategic freedom, a freedom on which other freedoms depend. The difficulty with the anti-hate provisions of the human rights legislation, there are basically two problems with it. One, it's too vague, and secondly, it's too wide. When it talks about the willful or the exposing people to hatred or contempt, I submit that with all the definitions in the world, the problem is that it still remains vague. We know that freedom of speech is often most important when it expresses strong disagreement. But where does strong disagreement leave off and hatred begin? Had they talked about, as Professor Moon recommended, using violence as the focus, there probably wouldn't be the difficulty that there is. But hatred is a necessarily vague term. And then, of course, we have the breadth, the width, and that is, it targets statements likely to expose people on various grounds to hatred or contempt, various constituencies. Likely to expose. There's no requirement that there be an intent to foment hatred, and there's no defense for truth or reasonable belief in the truth. I want to refer to a recent controversy because I think there has been a certain amount of facile discussion about it. And I'm talking about the complaint that had been filed against Maclean's magazine over the article written by Mark Steyn. It has been said, oh, well, that didn't rise or sink to the level of hatred, as though it was perfectly obvious that it didn't. I submit that it's anything but obvious that Mr. Steyn's article did not rise or sink to the level of hatred. I'm going to take one sentence from his piece. He said, of course, not all Muslims are terrorists, but enough of them are hot for jihad to provide an impressive support network. What does that statement effectively saying? That a significant number of Muslims support what? Terrorism, including the kidnapping, torturing, and beheading of innocent people. What worse can you say about people these days than that they support activity like that? I think it's anything but clear that a subsequent panel from the Human Rights Commission, or indeed the tribunal, if they ever get to deal with it, is going to reach the same conclusion as the last one did. We did a little research in our office about recent controversial issues. And I just want to read you a couple of extracts. They're quite short. An article written in the New Republic magazine, a respectable American publication. And on the controversy, the conflict in Kosovo, this is what it said. The conventional thinking is that we have no quarrel with the Serbian people. It's their leader, Milosevic, and his henchmen who manipulated them into waging so many brutal wars. But what if it isn't true? What if the Serbs actually support ethnic cleansing? In that case, we do have a quarrel with the Serbian people. I myself used to believe that ordinary Serbs have been deceived and bullied into accepting atrocities done in their name. But now, after 5 years trying in vain to elicit expressions of remorse from the hundreds of Serbs I have met, I'm convinced that the latter assessment is the accurate one. Whatever else we do in Kosovo, we must face the fact that for all intents and purposes, many ordinary Serbs are, to paraphrase Daniel Goldhagen, Milosevic's willing executioners. Is that not likely to expose all kinds of Serbian people to hatred and contempt? And we have Daniel Goldhagen's book, and here's what he says about the state of mind of the German people at the time of the Holocaust. He says the perpetrators, ordinary Germans, were animated by anti-Semitism of a particular type that led them to conclude that the Jews ought to die. Simply put, the perpetrators, having consulted their own convictions and having judged the mass annihilation of Jews to be right, did not want to say no. Is that not likely to expose a whole generation of Germans to hatred or contempt? Indeed, I know that Daniel Goldhagen is a controversial historian, but no one questions his historical credentials. There has been literature that has attempted to document the collaboration, the cooperation that the Nazis received from the indigenous populations in the various countries, or in some of the countries they occupied. This leads to a very interesting question. To what extent could Section 13 make it an offense to tell the truth about the Holocaust. This is the problem we see with this legislation. As a result, the Canadian Civil Liberties Association has taken the position that Richard Moon was very much on the right track when he suggested that the focus should be not on expressions of hatred, but on the prevention of violence. We may have some quarrels with some of the details, but the direction of the Moon report, in our view, is the correct one. All of which, Mr. Chair, is as always respectfully submitted.
Well, thank you very much, Mr. Borovoy. This time around, I'm assuming we'll begin with Mr. Ray. Please go ahead.
Well, thank you, Mr. Borovoy. It's nice to see you again, if I may say so. It's been our association goes back many, many years, and I'm very delighted to be with you in the room again. If I just can ask you a question. You stated at the beginning the three principles. You said freedom of speech can't be an absolute. Could you tell us what do you think the limits on freedom of speech are, and what are the instruments of public policy that should be used to enforce those limits?
I'm not able to tell you in the abstract because that engages my second principle. In the abstract, I can't tell you what the limits of free speech are. I could give you a few examples of limits in free speech. You're aware, of course, of Oliver Wendell Holmes' famous injunction, there's no freedom to falsely to shout fire in a crowded theater, an example. There are numbers of others.
But you correct me if I'm wrong, but I believe you didn't answer the second half of my question, but that is to say, you advocate, as I take it, that Section 13 should simply be removed from the Human Rights Act?
I think the best way is to remove it, leave the Human Rights Commission in the position of dealing with traditional issues of discrimination for which it was originally created.
What about the criminal code?
The criminal code, as far as we're concerned, if the key section were narrowed to deal with violence, the prevention of violence, particularly in situations of imminent peril, that would be much closer to the position that we would advocate.
So the so-called Cohen Report of 1970, with which you're very familiar, because the debates in Parliament around that time were also very much informed by your views and by the debate that ensued at that point. So you would remove Section 18 that would prohibit the advocacy of or the promotion of genocide?
No. Our concern would be 319, dealing with hatred. That's the key problem.
With respect to the incitement of hatred and the will for promotion of hatred, you would what? You would take away that section? You would change that section?
I would replace it or amend it with something that was focused on in the incitement to violence in situations of imminent peril.
So you would say that it would only be that anybody who communicating statements in a public place who incited hatred against an identifiable group, which says here where such incitement is likely to lead to a breach of the peace. That's the current provision.
Difficulty with that is that's so wide it could include situations where the person is provoking an attack upon himself. So that, well, you could have a situation that we've generally referred to as the heckler's veto. You don't want to penalize the speaker because of the violence of his audience. You may penalize the speaker if the speaker is urging the violence by his supporters against others, but not if what he says is so unpopular that he's attracting the violence to himself.
What about the argument, Mr. Borboy, that would say that if you simply leave it to the criminal code, which is you'll have to admit is a remedy that's been used very infrequently, you are in effect saying that the more if you like less drastic powers of the Human Rights Tribunal, which doesn't have powers to imprison people or take away their freedom in terms of their freedom of movement by incarcerating them, but simply has the ability to fine people and obviously we hope will discourage conduct, but it's never been challenged on the grounds that it's criminal type legislation. That in fact what you're doing thereby is perhaps forcing the authorities to use the criminal code more frequently than they otherwise would, and use an administrative tribunal, instead of using an administrative, which you'd use less frequently. I can't claim to be as articulate as you, Alan, but I mean, help me out here. You know what I'm trying to say, that you're going to end up with using more drastic punishment rather than less drastic punishment.
In addition to everything else, you're attributing clairvoyance to me. I do appreciate where you're going with this, and I would suggest to you that it may be overly influenced by a key fallacy, and that is that we either use legal sanctions or we do nothing when there are hate pronouncements. And I happen to be of the view that there are many things that citizens can do in a democracy, both to curtail, reduce the influence of, or reduce the number of occurrences of hate speech that don't necessarily require legal sanction.
But you would agree with me that from the point of view of taking, and certainly there are lots, and you and I and others have participated in several means and ways in which we attempt to denounce and demonstrate and pronounce against and show our rejection of any expression of hatred in a number of circumstances that have neither invoked the actions of the Human Rights Tribunal nor invoked the responses of the criminal code. And so you're obviously right in that regard. But it does seem to me that what you're doing by advocating just simply eliminating Section 13 rather than revising and amending it as a sort of the alternative path that's been set out, I think, by a number of people, including the sort of an alternative presented by Professor Moon in a very even-handed way as he looks at presenting his options. It seems to me that the risk that we end up running is that we lose the benefit of having we all agree, a more tightly focused Section 13, but one that nevertheless still gives certain powers to the Human Rights Tribunal to do its job. And that's where I think the difference of opinion will be on the committee, and where I think it will be in Parliament. If we lose that, we end up,
in that regard,
with an open field. Effectively, we end up with an open field, and the criminal code in place, and the criminal code is a very tough route to follow in these circumstances. And I think the history of the trials and the cases with regard to the criminal code will show that I think I'm right in that regard.
In that regard, well, there have been numbers of situations that maybe didn't lead to prosecutions or didn't lead to convictions, but did lead to some pretty unpleasant harassment of legitimate speech as a result of the anti-hate section of the criminal code as well. But there are other provisions even there that are less drastic than the normal prosecutorial instrument is, and Richard Moon himself recommended there can be certain action taken against certain websites that may have material on it that run afoul of the law, and prosecution wouldn't be a necessary remedy there, but it would be helpful in removing some of the material from the marketplace, assuming that that material contravenes what I say ought to be the barrier.
Thank you. That ends that round of questions. Monsieur Dorian, vous avez la parole.
Oui, je vais vous poser.
Thank you, sir. I have a question on a subject very similar to what you've addressed, the issue of negationism. Can you hear the interpretation? The issue of negationism.
Négationnisme, ça va? Finalement,
There are two theories. Some people believe freedom of expression should be defended to the utmost, that you cannot impose a historical truth officially, and others say, take the victim's side. In other words, if I'm attacked by thugs and that I go before the courts and I get them convicted, and that later on these same thugs or friends of theirs say that I invented this crime, that it never occurred to me, I think people who act in this way will in fact increase my pain and suffering, because the first requirement for someone who has been the subject of such pain and such injustice, really, it has to be recognized that they've gone through this. So there's that debate between people say that you can't impose historical truth. People are entitled to believe what they want, say, in terms of the Holocaust. And other people, such as those who defend victims. What is your position on this? How do you personally defend? What do you personally see here?
I am not one who thinks that a democratic society has any business determining what its citizens shall believe. Having said that, and thereby using legal sanctions to enforce it, having said that, I'd be very much in favor of using numbers of other sanctions if people make obscene, racially obscene remarks. Example, when Keekstra, when the material was revealed, that what he had done in his class, he was removed from the class, he was ousted from the teaching profession, and the voters of the community of which he was mayor voted him out of office. I think that was entirely appropriate. Those were sanctions, but they weren't the legal sanctions. They weren't illegal, of course, but they weren't the sanctions of the law. They were the sanctions of public opinion expressed in, I think, very constructive ways. And at that point, I saw no point in prosecuting him. He should have been allowed to wallow in the obscurity he so richly deserved.
Merci.
All right, Mr. Marsden.
Well, thank you, and I certainly appreciate having this witness before us today. I would suggest, sir, that when you referred to the Canadians who stand up to intolerance or stand up to hatred, you could practically include everybody in this room in one fashion or another. I would suggest that many of the folks that are here elected, part of the reason we wind up in this place is our standing up for rights of people in one way or another over a period of time, which then gives you a little bit of name recognition. In Hamilton, we had a Strengthening Hamilton Community Initiative, which was dealing with the aftermath of a firebombing of a Hindu Samaj following 9/11, a hate crime, a very serious hate crime. The individual couldn't tell the difference between a Samaj and through a mosque. We had the Community Coalition Against Racism, and there were times that one or the other of these organizations would raise uncomfortable issues. And to some extent, you've done so yourself here today when you talked about the complicity of the peoples of Serbia and the peoples of Germany and how far that should go. But one of the things that struck me that was a little concerning, you made comment that perhaps the Commission would be better off if it looked at violence, imminent violence issues. But to my mind, violence is usually something that happens in the heat of the moment, and there'd be more responding on their part and after the police had already investigated or whatever. When it comes to the sending out of hate on the internet or the media or wherever it goes, I would suggest that this Commission is well placed to deal with that, with those areas where perhaps police forces aren't quite as sophisticated on the ground because they haven't had the time working with it. And I'm drawn to this report, and I'm not so sure that it's been available to you that the Commission has made to the Parliament. But they did allude to some things in it today that are quite striking. Add a statutory definition of hatred, because that's one of the places where it's easy to misplace what is hatred and what is not. And it says, in contempt. And the important thing for me, it draws us back to the Supreme Court of Canada and the rulings as a foundation for taking these determinations as to how we are going to make applications of the legislative designation of what the Commission is supposed to do. It goes on talking about costs and things of that nature, but this report seems to be addressing in a way some of the concerns that's been out there in recent times, and I think that there's a real effort. As you can see, I'm making more of a statement than I am a particular question, and certainly be free, sir, to respond in any fashion you feel like. I'm frightened that a body that we have in place, the Human Rights Commission and the tribunals, which is tasked with one of the most difficult jobs in our country, is because of one or two, and very serious issues, but one or two judgments that were made, is being put at risk by people in this country that could minimize or contain their abilities to do their job. And so coming back to where we're at with all of this is to find a way that if they have strayed, and that's a large if, but if they have strayed, then judging by the opinions of the court and whatever legislation that may well flow out of this determination as to how we address it. But the important part is that we don't minimize their ability to perform a very serious and very important job. And if you look at what happened in Nazi Germany and what happened with the Kosovo and the other areas, if you'd had a Human Rights Commission in place in years before, there's a chance that people like Hitler would not have sustained the power that they did in the manner that they did over the years. So I think I've opened a door here that I'm sure will have many a comment.
Well, just one word about Germany. The Germany of pre-Hitler Germany had anti-hate legislation very similar to what we have in Canada now. And in the 15-year period before Hitler came to power, there were more than 200 prosecutions based on anti-Semitic speech. And in the opinion of the leading Jewish organization of the day, they thought the prosecutions were well handled some 90% of the time. That, I don't think, is going to be all that. It didn't matter at the time it was most needed. Now, when you say what you do about the Human Rights Commission, that what I'm advocating may disable it somehow, I would say au contraire. I began by making the point that I'm very much in favor of the rest of what Human Rights Commissions do, and I think those programs should be strengthened. I do not think the provision or the addition in the human rights legislation of the definitions of hatred would help all that much. In fact, I was rather surprised that anyone would think it would make that much difference. Just to give you one example, the definition talks about strong detestation. I ask the question, is strong detestation any more clear than hatred is? And that's just the problem with these definitions. And it's not their fault. It's not the fault of the judges who wrote it. That's the problem when you have words like that, when you make words like that the basis of an offense in law. There's inherent, inescapable vagueness. Now, human rights commissions could still perform a valuable function where expressions of hatred are concerned. They have an educational mandate, and they could make increasingly imaginative use of that mandate to promote, to publish responses, and to undertake preventative programs. There are all kinds of things human rights commissions could do. In all fairness, I'm not as au courant with what commissions are doing these days. I've been drifting into other fields. But I know at one time I worked rather closely with Dr. Daniel G. Hill, the first director of a Human Rights Commission in Canada, the Ontario Commission, and he had a lot of imaginative educational programs. And I think there's lots commissions could do about it. That's why I say I want to get back to the response I gave to Mr. Ray earlier. It's not an either-or proposition. We don't have to use the legal stick or do nothing.
I would agree with you on the term that addressing racism, and a lot of the hate that we hear of is blatant racism. And addressing late racism by education is the only way to deal with it. Because my experience is racism is a learned behavior. I'm very fortunate. I grew up in northern New Brunswick, and I was never exposed to people from any other race but our own. There was a friction between English and French. And when I came to Ontario, and particularly to Hamilton, and I saw exhibitions of hate, particularly in the early 70s.
We're just over our time here, actually, Mr. Marston, so I hope you can come to your question.
I will come to it very succinctly. But seeing open racism against Sikhs in Hamilton in the 1970s shocked me. And I must say that that's probably one of the reasons that I value very dearly the work of the commissions, and as you say, you do as well. So I'll end there to leave more time for the government.
All right. Thank you. Mr. Sweet, I believe you're next.
Thank you, Mr. Chairman. I'm going to give the bulk of my time to my colleague, Mr. Hebert, but I did want to say a couple of things. First off, I agree with you, Mr. Borovoy, of the large portion of good work that the Canadian Human Rights Commission does. I think that the Commission is suffering from something that there's a phrase in U.S. jurisprudence that the United States justice system doesn't only have to be just, but has to appear just. And I think there's an issue there of credibility now publicly that they're going to have to deal with. And the one witness mentioned about the things in the media, and I understand that we deal with the media all the time and trying to straighten out stories. But one of the things that you had mentioned about the breadth and scope of Section 13 is, I think, as well eluding the Commission in the sense that although the Canadian Human Rights Act was not meant to be punitive but remedial in nature, because it would damage anybody's reputation beyond their capability to recover it by just going to a tribunal, anyone who has a complaint forged against them, which is easy to have happen because of the breadth of it, has to seek legal counsel because they would be terrified by going to a tribunal that would be public, and then they would be named as a person that would be, of course, guilty of hate speech. And so that's one of the main concerns that I have around the issue, and you can comment on that, but I want to leave the questioning to my colleague, Mr. Hebert.
Perhaps what I can do is work my response into my reply to Mr. Hebert in the interest of economy of time.
Thank you very much, Mr. Borovoy, for that and for, again, agreeing to be here today. The Canadian Human Rights Commission, in its special report to Parliament last week, suggested that there is a, quote, right to freedom from hate. In your opinion, is there a right to a freedom from hate, or does it mean, or is it the case that freedom of expression in a society sometimes means that people will be offended?
Well, of course, you can't have a viable free speech unless people are likely to be offended. It just doesn't otherwise exist. But as far as the more, if I may say, metaphysical question you're asking, is there a right to freedom from hatred? That really depends on one's ultimate philosophy, and I don't know how philosophical you want me to get. But as far as I'm concerned, the rights we have are creations of the law. Apart from that, I don't understand what we're talking about. So that if you create a freedom from X, then you've got that right. If you don't have that right. I don't see these things existing in a state of nature. So if you're asking, if the questions you're asking me are at that level, I beg off because that's not my area.
In brief, in Canadian law, is there a right to freedom from hate?
Sorry?
I said in brief, in Canadian law, is there a right to freedom from hate?
Yes, of course. The anti-hate section of the Criminal Code has made it, has created that right to freedom from hate.
And is it your belief that that right should exist in Canadian law?
No, for all of the reasons I gave earlier, no, because it's too vague and will lead to unwarranted restrictions on legitimate speech.
Thank you. In the same report from the Commission, the Chief Commissioner herself recommended that there be an opportunity for court costs, for legal costs, to be awarded to the defendant, to the person who's responding to the complaint, in cases where there's abuse. In my mind, it would seem that, well, in a real court of law, we know that court costs can be awarded not only for frivolous or vexatious lawsuits, but also in cases where a person was innocent and the judge felt it appropriate that the complainant bear the costs, whether or not it was abusive or not. Would you agree that costs in these situations should be allowed to be awarded to those individuals who are in fact innocent, keeping in mind that complainants do not have the benefit of legal advice provided as it is to the complainants themselves? The system is very skewed against the person that's trying to defend their reputation, and it would seem to me that having a regular process where a complainant has to keep in mind that they might have to pay the court costs of the person they're complaining against would be a good deterrent against frivolous or vexatious complaints.
It would probably also be a very effective deterrent against using the human rights legislation at all. And I think that is just the problem with it. To say that there might be some remedy for costs isn't to say that the costs ought to follow the event as it so often does in court, and doesn't say that the complainant should necessarily be the party that's bearing it. I think these are much more complex than that, and I don't know whether you intended this, Mr. Hebert, and if you didn't, just stop me. But when you talked about a real court, I became a bit uneasy. And that is because real justice is dispensed in by many different tribunals in our society, and there's no magic in wearing the legal kimono or against wearing an ordinary business clothes.
The reference I was making was to the fact that in the regular judicial system, there's different rules for evidence. There's different rules for handling these kinds of complaints that don't, from my knowledge, apply under the current Human Rights Tribunal. That's the differentiation that I'm trying to make. Last of all, and I think this may be my last question, you did give an invitation to ask more about other legal sanctions. You know, it's not just about whether the other sanctions, not legal sanctions. There's the fallacy of legal sanctions versus nothing. You suggested that there are other sanctions that can take place. You gave us an example in Keekstra. Can you give us other examples that would inform our committee as to how these complaints could be dealt with without the law in place?
Of course, in some respects, this is already happening. There may be situations in which it ought to happen more. But very often, when a person of some standing in the community makes a racist statement, all hell breaks loose. People begin denouncing them all over the place. I think that's a very healthy response and ought to be encouraged. Human rights commissions at various times might even publish documents responding to some polemics in the community. That's also a good thing. And then there's also the indirect stuff. When the sanctions, the legal sanctions against discrimination are vigorously and imaginatively used, it helps to create a climate favorable to human rights and, if you like, inimical to hatred in the community. The more you see of that, the more helpful it is. And I would encourage that. So these are some of the ways we deal with these things. When those kids walked out of school in Keswick, when this youngster was being penalized, and they just walked out, they were engaging in the kind of conduct that helps to shore up this feeling in society.
Thank you very much, Mr. Borovoy. I do want to just draw the attention of members of the subcommittee to an important scheduling matter. On Thursday, we will be meeting at 12 instead of our usual 12:30 time slot. That's to permit us to have 1 hour to question Professor Martin, who will be our witness, followed by an hour in camera to begin drafting giving instructions to our analysts on our report on human rights in Iran. On the basis that there may not be enough time in that hour to give full instructions after all the hearings we've had, I've also convened a second meeting, which can be cancelled if we don't need it. That will take place at 3:30 on Thursday so that we can finish our drafting instructions. With any luck, we won't need it, but if we do need it, it's there. It's easier to cancel than it is to set up a room de novo. So on that basis, please clear your schedules, and please take advantage of the 2 days you've got to organize yourselves and to ask any questions you have to our analysts so we can come prepared for that. Thank you very much, everybody. We are adjourned.